Yeah, so, Mr. Newera, what do you do now?
Doctor, I think if it is possible, my lord, if
Yes.
the learned counsel for the first and second just so we make progress with it. If we take a short counter, send it to them here, and they look
We can do what?
we can take a short countdown so I can send it to them via mail. They can look at it. If they will allow, we just because it's actually a very short paragraph and it's not that long. If they will allow that, I can send it to them via mail even now, so they can look at it. Then we can make further progress. We are less than 30 minutes. If it is convenient.
Oh, my lord.
Yes, Mr. Abdullahi.
I also agree that if we can get the process via mail because we don't have any right to even respond to those processes. We can get it via mail now, probably in another 30 minutes or 1 hour.
But okay, but do you still have any right to?
And that's what I'm saying, that we don't have any right to reply.
Yes, because
just for us to see what they've argued what they've said in the reply. So you can send it to us.
Okay, if Mr. Newera will be able to send the replies to Mr. Abdullahi, we can stand down the matter for 30 minutes. And also the further affidavit to Mr. Ekene.
My lord, we have an application which while Mr. Newera is doing that, probably we can quickly take the application. This application to regularize our statement of defense, which was filed out of time.
Is it Abdullahi? Who has an application to regularize? But I thought it was on the last adjourned date.
No, we have another application. The last adjourned date was an application to file our counter out of time. But this is an application to file our statement of defense out of time. We filed the statement of defense subsequently and brought an application to regularize that.
Okay, you don't file your defense? Abdullah, you don't file your defense?
We filed the defense.
Okay,
we have filed the defense. So we filed on the 6th of October.
But as at the last agenda, did you file the defense? Okay, it was filed on the 6th of October.
It was only our counter that we filed. So with that, we brought an application for the counter. Now it's an application for the statement of defense to be filed out of time.
Okay, Mr. Newera, Mr. Newera, you should unmute yourself. You are muted.
I'm sorry, my lord.
Were you served with the first defendant application for a session of time?
Yes,
to file his defense?
Yes.
Okay, yes, sir. What about Mr. Ekene?
Well, Mr. Sir.
Oh, then can we take the first defendant application to extend time to file his defense? Can we take it?
No problem.
Yeah. We can, my lord.
Okay. Yes, Abdullah.
My Lord,
Yes,
before
Abdullah.
my Lord is an application dated the 27th day of September 2021, but filed on the 6th day of October 2021. My Lord, the prayers, we respectfully urge my Lord my Lord's permission to move the said application in terms of the motion paper.
Okay. Hey, while we are checking the application, Mr. New Era,
Hello?
I say while we are checking the application, you shouldn't forget to send the replies to the Mr. Abdullah via email.
Already found out.
Huh?
So we already turning it at the
Okay.
we tend to
Okay.
get responses.
So first the final application for extension of time to file its statement of defense dated the 27th of September 2021 and filed on the 6th of October 2021 is granted as spread.
Court places.
Yes. Yes.
Another group probably ask for
He said?
so we will not ask for the countdown so that the process can be sent to
No. I thought you where we were. So can we? Is it on how many minutes?
test down 10
Hmm?
minutes. This process will be sent to the council. Because we have already done 2 of them, just remaining the last one.
They've already scanned or done what? They have already done what?
They done 2 of the process. The first, the supply of point of contact, supply of point of contact. And what is left now is to further appeal that.
Okay, did you say you've sent the reply on point?
So you can discount, but just oblige me your email so that I can send it to you right away.
You can use the email on the motion that was just argued now. The first email address, forcelawpartnership@gmail.com.
So should we resume by 15 minutes after?
Yes.
15 minutes after 12?
My lord, I think, okay,
Yes.
okay, I think it's okay, my lord.
It'll be fine. I believe by then we would have received and also gone through it.
Okay, okay.
We are grateful, my lord.
Thank you. Can we, hello?
Hello?
Yes, my lord.
Yes, before then,
Yes, my lord.
how do you see? Anyways, it still doesn't, just an oral application to, let them get some copies first, so that will take your oral application to regularize. Or can we check the oral application to regularize the
My lord,
huh?
I think we can take it.
We can take it, my lord.
Okay. Yes, so new era, you want to apply orally to?
Yes, my lord. We apply orally, regularize our apply for that. One day, the default fee that we pay.
So, Mr. Abdullah, no objection.
My lord, no objection, man.
Mr. Kenny.
No objection, my lord.
Okay.
present. Please, can you send it to my WhatsApp? I cannot download this picture. Ask me to get permission because you need a Gmail account to send it. No. Ask me for permission. No Gmail, I give you answer that problem.
So claimant's oral application for extension of time to file is replies and further affidavit to the first and second defendants' counter affidavits is granted as spread. Accordingly, processes already filed on the 6th of October 2021 are deemed as properly filed and served.
As first places.
Yes. So the matter remains stood down back to 12:15.
Stop places.
Okay, thank you.
Okay.
Hello, yes, are we set? The Mr. Abdullahi.
My lord, sir.
Yes, we are set.
Have they been sent? Have the document been sent?
Yes, the documents have been sent. We've received them.
Okay, received them. You have gone through them.
Yes, I've gone through them.
Okay. Yeah, Mr. Abdullahi, can you
My lord.
know any issue? Yes, can we check the application? No any issue?
No,
I mean, with
no.
regards to the further, okay.
No new
Mr.
issue.
Abdullahi. Okay. Mr. Abdullahi.
No, we can take the applications. No,
Okay.
we have no issues with it.
Yes. Okay. Mr. New Era.
For my lord, is an application for
I can't hear you well, Mr. New Era.
well, I said we have an application, a motion notice for Kaluku junction.
Data on file.
Motion is dated 17th day June 2021 and 5/18th of June. So, the application frame for order of for Kaluku order of during the death or any person of their doctor or any other person passing on or carrying out test or any other like head of or any of the nationwide. Any carrying of- So the application is supported by an affidavit of the law paragraph. And at the end, yet is SS11 to SS13. But also support the application for the affidavit posed to by Jeremiah there.
New Era. New Era. How many paragraphs?
This is supportive affidavit on further affidavit.
No. The affidavit in support.
It's 31 paragraph.
Yes.
And it's dated in
How many exhibits?
13 exhibit. That's exhibit SS11 to exhibit SS13.
Okay. So 13 exhibits were attached. 13 exhibits were attached.
Yes, my lord.
Yes.
My Lord, also supporting the further affidavit dated.
Also, there is also a written address.
Yes, I wanted
You also filed a written address, huh? Okay, yes, I can hear you. Sorry, I can hear you. Mr. Nuyara, the quality of the audio is poor.
Lord, can you hear me now, my Lord?
Yeah, I can hear you. Yes.
Yes. Well, I have wanted to adopt the further affidavit before proceeding to the written address.
You wanted to
Adopt the further affidavit.
Okay,
before
along with the okay.
proceeding with the written address, unless my Lord orders otherwise.
No, it's okay. It's okay. It's okay.
My Lord, the further affidavit is dated the 18th, the 7th day of October, 2021, and it's of 11 paragraphs.
We have also filed a further affidavit of 11 paragraphs. Yes.
Yes, paragraph. Dated 7th October.
Dated
7th October 2021.
Okay. Yes. Yes.
My Lord, we also filed of court, also filed written address.
That's the replies.
No, the written address now, my Lord.
Okay.
Dated the 17th day of June 2021 and filed on the 18th.
Yes.
2021.
Yes.
Lord, I don't know if I should proceed with the reply or the
Yes. You should adopt everything at the same time.
Lord, in response to the counter affidavit written address filed by first
Yes.
we filed a reply dated 7th day of October 2021 and filed on the same date, my Lord.
Okay.
And also, my Lord, in response to the written address filed by second federal respondent, we also filed a reply on point of law dated 7th day of October 2021 and filed on the same date.
Yes, Nira, I can hear you.
My Lord, we rely on all the advanced affidavit support together with the exhibit attached thereto and the further affidavit address the support of the application together with the true reply to point of law, urging my Lord to grant this application and restrain the pending respondents from carrying out any act of picketing or protest in the premises of the claimant applicant.
Okay.
If my Lord will allow me to just highlight one or two points.
Yes.
My Lord, sir.
Yes.
Application is hinged on two fundamental.
The audio is still poor.
Can you hear me very clearly?
I can hear you very well. Yes.
Okay. Okay, I said, my Lord, this application is hinged on two fundamental
Well, can you hear me?
I can hear you.
Okay.
Okay. I can hear you. Okay. Okay.
On two fundamental.
Yes.
Okay. This application is hinged on two fundamental points, my lord.
Yes.
The claimant applicant has a right to protect.
Yes.
Second is that the balance of convenience is in favor of the claimant, considering the circumstances of this case. Well, we understand that this application of this nature is a discretionary application, which is subject to the discretion of this honorable court. However, my lord, in granting or refusing same, it is expedient that the exercise of discretion must be done judiciously and judicially. And my lord should be very careful at this time not to delve into the matter. Having said that, my lord, as related to legal rights, the applicant, by virtue of paragraph 5 of his supporting affidavit, has disclosed before the honorable court that it has a right to carry on the business of banking, being a licensed financial institution in Nigeria. Well, this right is what the defendant respondent are threatening right now. Intending or planning to carry out the right protest on the premises of the claimant applicant.
But is any person denying the claimant that right?
Not yet, my lord. Not yet. What they are planning is to deny the claimant the right. To limit their rights in that regard, my lord. Carry out or protest. What it means is that the entrance to the claimant applicant business premises will be blocked, and nobody can gain access to it. And in doing that, they are hindering the rights of the claimant applicant to do business.
But Mr. New Mr. New
Hello, sir.
What about the rights of the members of the first defendants to have their salary? Under the TIA agreement, the transaction implementation agreement. Can you hear me?
Very well, I can hear you, my lord.
Yes, under the TIA, plus 9.24. All right. 9.24. There is an obligation on the claimant.
Yes, my lord.
And yes, my lord. Who is going to benefit from that obligation?
Yes, my lord, we are completely free from that obligation. The reason we say that is because
no, what I want to know who is going to benefit from the obligation?
My lord, sir.
I say who is going to benefit from that obligation under clause 9.24?
The persons to benefit according to
the members of the best defendant. Is that right? Yes.
Yes. Yes, my lord.
And from the CIA, that credit line will be written off by you.
By the court, my lord.
No, I said from the transaction implementation agreement. That obligation under clause 9.24.
Yes, my lord.
Will be written off by the claimant.
Yes.
So it means it's not even it's an obligation of the claimant be benefited by the members of the first defendant. Is that so?
Yes.
So, prior to this agreement, you granted the second defendant a facility of 9 billion naira.
Yes, 1.9 billion.
Yes. And, you know, when you went to the Federal High Court to claim that 1.9 billion naira.
Yes, my Lord, sir.
What has that 1.9 got to do with your obligation under the what does the 1.9 billion naira, what has got to do with your obligation under the
Yeah, my Lord, I can barely hear you now. It appears someone is having two devices connected at the same time. Or perhaps Tanses on the other side should mute their mic, because I can hear you still.
My question is that you have an obligation under the transaction implementation agreement.
Yes, my Lord.
By virtue of clause 9.24.
24, yes.
And prior to that agreement, you granted the second defendant a facility of 1.9 billion naira.
Yes.
And another thing is that obligation under the agreement, by virtue of clause 9, will be benefited by the members of the first defendant, not the second defendant itself, not the second defendant, but members of the first defendant.
Yes.
Then what has the 1.9 billion naira got to do with the amount in clause 9.24? What is there any relationship between the two? It's not the second defendant that's going to benefit from that obligation.
Yes, my Lord. My Lord, the 9.24, my Lord, placed the obligation on the claimant to pay the money to the first defendant, not the second defendant rather, not the first defendant directly. And the second defendant, my Lord, the 9.24 places an obligation on the first, on the claimant to pay the money to the second defendant for the benefit of the first defendant.
Yes.
So the money was not really meant to be paid directly to the first defendant members. Well, in any event, my Lord, in any event. Now we have paid the second defendant was owing us money, and what we did was to set off the money they were owing us. And the court we went to, and they were still balanced out of that money. And we went to the Federal High Court, and the said set off was affirmed. My Lord, if my Lord looks at
sorry. How much is the money that will be paid to the members of the first defendant?
Well, it has not yet been ascertained, because I looked at my record this morning.
So it's not ascertained, but you decided to offset that obligation with the liability of the second defendant.
Yes.
To you. So something that's not even ascertained, and you are setting it.
Well, my Lord, the first defendant member.
You are offsetting something that's not yet ascertained with the liability of a second defendant.
My Lord, the first defendant members did not work for the claimant.
But
so it was,
I'm talking from the agreement. This is what it said. It said, for purposes of UHSL settling outstanding staff liabilities, create a credit line for UHSL, which shall be applied solely for the purposes of the staff liabilities, solely.
Yes.
For the purpose of staff liabilities, provided that the credit line shall subsequently be written off entirely by UBN.
Yes.
That's what it says, yes. And this obligation of yours, you want to set up this obligation with the liability of the second defendant to you.
Yes, my lord, sir. My lord,
Yes.
sir. You see, the truth is, we don't have, ordinarily.
Okay, so
Mr.
Mr. New Era,
My lord, sir.
it means the members of the first defendant will never get their entitlement. No, hold on. It means they'll never get the entitlement until and unless the second defendant agrees, to accept your condition that obligation under the TIA agreement will be, an additional liability on the second defendant. If the second defendant doesn't agree with your condition, then it means the members of the first defendant will never get their entitlement. Is that so?
My lord, that is why it is even more strange that the first defendant, members of the first defendant are pursuing the claimant only.
Yeah,
their employers.
Because you are the ones that are going to pay.
My lord, sir.
The money will come from you, from the
lord, we have a
TIA.
My lord, we have a situation, my lord. This is our predicament. My lord, this is our predicament. Now, if we are to pay this money to the first defendant members, without that obligation on the part of the second defendant to say, okay, we are accepting this as a loan, but it will be a predicament on our part, and that is because the first defendant, they owe us, and that loan has been written off by the judgment of the Federal High Court. Now, if we don't have their affirmation that, even if we don't have the affirmation that what we are giving them now is a loan, what it means is that whatever money we are giving them is more like we are paying more than we are supposed to pay under the TIA agreement. And the judgment of the High Court was very clear that it's set up with obligation.
New era.
Hello, sir.
The amount of 1.9 was a facility given to the second defendant.
Yes,
and you've got judgment. You've gotten judgment with respect, with regards to that amount.
Yes, my lord.
So you can go and claim your 1.9 from the second defendant anytime, anywhere, but not to withhold. You understand, the money meant for the benefit of the members of the first defendant.
Yes, my lord.
As lien or whatever. You understand?
Well, I perfectly understand, my lord.
You have gotten judgment. You have had your judgment. Is there intact? Although it's appeal against, but it's still there.
Yes.
So with that judgment, it means you can recover your money from the second defendant anytime, anywhere. Is that so? That's the 1.9 billion naira.
Yes, my lord.
Okay, so so you are not cleverly offsetting your obligation under the clause 9.24. Yeah, so what is meant for the benefit of the ex-staff of the second, not for the benefit of the second defendant. No. Not for the benefit of the second defendant, but it's ex-staff. Please, Mr. New Era, is that fair? Is that fair, please? I just want to. Is that fair?
My lord, sir. Well,
yes.
My lord.
No. Is that fair, please? And please, is that fair?
My lord, it is not fair on our part also because the employers. What is even more worrisome now is that the first members of the first defendant appears to be working hand in hand with the employers to fight their employers who are actually owing them, to fight who were not even their employer. So if they are pressuring us, my lord, they are also pressuring the second defendant. This is that
there is obligation on you. Obligation on you under clause 9.42.
They were not a party to the agreement, my lord. They were not a party to the agreement to begin with.
Okay,
by the laws,
my
lord, you can't even enforce the contract as it is.
But they are beneficiaries.
Yes, my lord, the law is that even a beneficiary to the contract cannot even enforce if they are not parties.
Okay. The judgment given by the National Industrial Court against the second defendant, how did the members of the first, defendant got that judgment? Didn't they refer to the agreement?
Well, I can't confirm that for now, but I know that we were not sued in that case.
Yes,
we were not
yes,
sued.
yes.
The person that we were sued was the second defendant.
Yes.
But my lord, in any event, my lord, this application, like we tried to argue in our reply, is that this application is a interlocutory application, which of course, the substantive case will be dealt with in the appropriate time. But my lord, what is before the court now is whether the court can, in the circumstance, so that the rest before the court will not be, jeopardized. The issues before the court will not be jeopardized before my lord has the opportunity of hearing substantive matter. So my lord, we are saying that, okay, put them in check for now until my lord decides the substantive matter. So that is what is before the court for now, as far as this application is concerned.
Okay, then let me ask you.
These issues are for the substantive case. So whether or not we rightly did what we did, but it's for my lord to determine the substantive case.
Okay, let me ask you one question. How are you going to advise the members of the first defendant to get their money from, from both the claimant and the second defendant? How if you're a lawyer to the members of the first defendant, how are you going to advise them to get their money?
My lord, if as they are drawing our trousers now, they are drawing the trousers of the second defendant. My lord, both parties will be on fire. So now that we are saying that we will not, give any further until they accept it as a loan, my lord, they will also be considering that option too, because it appears the second defendant and the first defendant, they have teamed up to fight a party who is not their employer. And that is where the problem is, my lord, because the second defendant is appearing to have a kind of a smooth sailing in all of this, because he is actually the one at fault. Because before the TIA, they were their employers and they were the one that owned the obligation to pay their staff. We didn't employ them, so we can't be for the TIA.
But you undertook to pay the ex-staff through the second defendant. You undertook under the clause.
Yes, my lord, we did that.
Yes.
But my lord, in any event, my lord, we have that's our case as far as the application is concerned.
Okay.
Lord, we have to look at this one way or the other and make this decision on it.
But that TIA, what's he saying? Is he saying that second defendant is going to be merged with the claimant or what? Or is going to be the content of the TIA?
Yes,
is it a merger or acquisition or what?
It was an acquisition by another company called Aso Savings. They acquired substantial shares in the second defendant.
Yes.
The company Aso Savings, they are live and they are going and they are well and they are
in which you are the major.
Their business is going on smooth.
Is that so?
So we didn't acquire
the claimant was the major
Union Homes.
Mr. Nuera, the claimant was the major shareholder in the second defendant before. The claimant.
Yes. They were a shareholder in the second defendant before. Yes, my lord.
Okay, it's okay.
We are grateful, sir. Thank my lord for the indulgence.
Thank you, Mr. Nuera. Yes, Mr. Abdullahi. Mr. Abdullahi.
My lord,
Yes.
Yes, my lord. Yes. We have appropriately filed our counter affidavit in serious opposition to the application for interlocutory injunction. Our counter affidavit was filed on the 24th day of September 2021, deemed filed and served on the 28th day of September 2021.
Yes.
My lord, the counter affidavit is deposed to by Tolu Akinmayowa, who is the legal officer in the employment of the first defendant. It is a 37 paragraph counter affidavit and we place reliance on all the paragraphs of the counter affidavit in opposition to the affidavit of the application for interlocutory injunction.
Yes. Is there any
My
exhibit?
Lord, accompanying the said, no, my
Is
Lord,
there
there is
any
no exhibit.
Okay.
No exhibit.
Okay.
Accompanying the said counter affidavit, we filed a written address dated the 21st day of September 2021.
Yes.
That filed on the 24th day of September 2021.
Yes.
My Lord, we adopt the arguments we made in the said written address in opposition to the claimant's applicant's application for interlocutory injunction.
Yes.
My Lord, may I be permitted to just streamline in 5 minutes the issues, the real issues for nation in this application. My Lord, we have argued in our written address, and I believe rightly so, that the affidavit in support of the claimant's application contains the same facts as those contained in the statement of facts in support of the substantive suit. My Lord, the very obvious thing. So they are relying on the same set of facts, the same set of evidence to in both this application and in the substantive suit. And my Lord, we have also argued that the application in itself is practically asking for the same thing the substantive suit is asking for, which is simply that the court should stop the first defendant from and his members from the office of the
but the reliefs in the substantive case. Abdullah, can you hear me?
Yes, but at some point he said my Lord said the reliefs in substantive.
What I'm trying to say is that the reliefs in the substantive case are picture, while the reliefs in the interlocutory application are interlocutory.
Yes, my Lord. That's we understand that the evidence in the interlocutory application, they practically say, okay, pending the determination.
They're just asking to restrain you, from carrying out picketing activities. Pending the hearing of the
yes, my Lord, but our argument in this respect is that in all purpose and manner, the reliefs are similar and they are almost the same thing. And the fear, my Lord, is that which the courts have decided on in saying that the court should not delve into the substantive suit at the interlocutory stage is that, my Lord, if the application is granted for interlocutory injunction, the claimant can actually go to sleep and use all tactics to see that the matter is delayed or never had, and they would have achieved the same aim as to what with what they want in the substantive suit. My Lord, we are urging your Lordship to seriously refuse that tactic, reject that tactic. My Lord, I want to also make a point or two on the responsibility the legal rights that they are shown to be asking for this application. My Lord, picketing, we've defined picketing is in our written address, and I don't want to go back to that. But picketing simply means peaceful demonstration, and it's a worldwide known industrial action that workers use to express their grievances. Now, my Lord, and I believe section which we quoted, section 43 sub 1 of the Trade Unions Act, has even given obligations on both, on even the first members of the first defenders not to what to do and what not do while carrying out picketing activities. So, my Lord, what the claimants have only tried to do is to restrict, to beat the first defendants and ask your lordship to also tie their hands and close their mouth from complaining. That's essentially what they've asked. They are coming to ask your lordship to do is, we can be beating these people, but my Lord, stop them from complaining. You should not come and show people that we are owing them the money. My Lord, we ask your lordship to resist this temptation to so do. My Lord, lastly, on the matter, the claimants' counsel has been hammering on the fact that the first defendant is conniving with the second defendant to fight who was supposed to be their employer, to fight them who were not, whoever their employer. But what I want to call our attention to is that the TIA itself, in essence, is the agreement with which the claimant sold. They sold their shares to savings. So, and it means for that to contain, to be for that provision,
they sold their shares to who?
In that,
the claimants sold their shares to
ASO savings. Their shares in union homes, their shares in second defendant was sold to ASO savings through the TIA. And why it means for the purpose and intent of the TIA, it shows that while negotiating that process of saying, ASO savings perhaps had negotiated that, you for probably in consideration of the amount we are buying this, we are paying you for these shares, you should get the ability of paying the staff of this entity that we are buying, whose shares we are buying from you. You should pay the staff their severance allowances, which they are not saying they did not sign it. They willingly agreed to that condition. And my Lord, looking at at that particular clause, it is very clear. We cannot run away from it. It is two things are very clear from that particular clause. That one, the claimant agrees to create a credit line solely for the purpose of staff discharging or paying the staff liabilities. Now, the second thing is the provisor is also very powerful, my Lord. The provisor says, provided the credit line shall subsequently be written off. This is UBN. This is by UBN. We know that if a party undertakes to write off, even if you say loan for sake of agreement, it means I'm giving you more or less a gift. I don't expect you to pay back. The claimants agreed that they will write off me when those liabilities are known and they are paid. They are not expecting anybody, including the second financier, to pay back whatever is paid, whatever credit, whatever stuff that is paid by them. This is a part of the negotiations, and the provisions of that CIA, which is the agreement they use to sell their shares. So, my lord, they cannot now want to run back to leave
But Mr. Nuera, why are you not putting pressure on the second defendant? Say, why are you not putting pressure on the second defendant to claim their money?
My lord, it is clear. It's clear why we cannot do that. One is that by the agreement, by the undertaking in the agreement, because it's an undertaking they gave, Union shall, by the undertaking, Union Bank has given us, or they have given us in the TIA. They've shown that we cannot even, because if we go after Union Notes, for instance, which is now owned by Aso Savings, another entity, they will only produce this TIA to say we've been discharged of this obligation by the undertaking given by Union Bank. So it will be a futile exercise for us to do that. Going by the clear and very unambiguous provisions in section 9.2 4.
Yes, because there's obligation
that is our argument.
Claimant to pay They give undertaking to pay that money to our members. Through you. Okay, through the second defendant.
My lord,
to pay the money to you through the second defendant.
Yes, they will create because of these monies as at that time. So they started that whatever amount it is, they will create the credit line for the second defendant to apply it. So the second defendant is more or less like a trustee in process. The second defendant is the trustee of those funds in this process. It means even if the money were paid to the defendant anytime, they can use it for any purpose too.
Okay.
But the money comes from, my lord, lastly, we also submit that the judgment, the purported judgment of the Federal High Court, which
it's not a purported one.
Claimant is,
it's not a purported judgment.
My lord, why? Okay, my lord, the judgment. I will draw that statement, my lord. Yes, I will draw that statement, my lord. The judgment which the claimant is brandishing to also stop this payment, and not none of the members who are beneficiaries were internally not sued. They were not sued in that judgment. They are not parties to that judgment. Because perhaps they know that if they had been brought the beneficiaries, probably the court would have seen clearly that this is just a ploy to deny a worker his lawful wages. And not we submit that your lordship should resist all attempts to use this court to perpetuate injustice against the poor. These people are suffering. We've stated in our affidavit, they have their members dying on daily basis. My lord, they have their members dying of hunger. They've even died. That's the real death since this matter started. So, my lord, it is very expedient that the claimant is made to see reason that why they should. And what we are even saying, what they are even what have come to the court to say is that no, my lord, stop these people from even complaining. That is just that it is even
the claimant is saying that the judgment of the Federal High Court affirm is in a position of setting its obligation CIA with your liability, equity with the liability with second
My Lord,
it said the judgment
by the
says,
admission of the claimant,
the judgment affirm the in the position of the claimant of setting its obligation under the CIA with the liability of the second defendant.
My Lord, that is the point we made, that that judgment which they got from the federal high court, we are not parties to that judgment. And this money they are even trying to set up is our members' money. It is not for the second defendant, so for the fact that we are not in that suit, it cannot be binding on us. What we are saying is that our money is still left unpaid, and you are the one responsible for the payment.
I was even saying to myself that why wouldn't you take the because I understand that this matter can basically be had on the documents file. Do you need any real evidence to to prove or disprove my understanding of the case, and from the argument that you are making, so that the court would not, in determining the substantive matter. It's like
my Lord, that's our argument. It is because we are danger to.
Okay.
So, and that is the reason, that's the fundamental reason for my Lord to refuse that application, because there is no way that application will come and it won't touch on substantive suit. We are most
Mr. Ikeni.
We ask my Lord to dismiss the application with cost.
Yes, Mr. Ikeni.
My Lord, in opposing this application, we filed with the post to a 21 paragraph counter affidavit. The post to Bayola Itonwa, and we are relying on the
C24.
Yes, my Lord. Sorry, 21 paragraphs. Sorry, 21 paragraphs. 21 paragraphs counter affidavit. The post to Bayola Itonwa, and we are relying on the entire paragraphs of the affidavit. We also have attached to the affidavit just one exhibit, which is a letter from the second defendant stating the situation to the first defendant, so the claimant. The affidavit was filed on the 22nd of September, 2021.
Yes.
We also filed along with the counter affidavit our written submission.
Yes.
Dated the 22nd of September, 2021. And we rely and adopt our written submission as our arguments to this application.
Yes.
My Lord, for purposes of brief adumbration of our written submission, yes. This is an application for interlocutory injunction. we state clearly that the core condition for a grant of interlocutory injunction is the existence of a legal right. And unfortunately, the claimant has no legal right to stop another legal right. The right, they don't. They don't have a legal right to stop another legal right.
There are two computer legal rights.
No, they have not shown any legal rights on them from the affidavits. What they are complaining of is also what we want to do.
Okay.
What the first defendant has a right to picket is as provided by law.
Okay.
The Trade Union Act states expressly, and my lord, we also cited the case of Chevron and Lupeng in our arguments, where the court, this honorable court, restated that right. You can't restrain people from picketing. It's a legal right. It's clear.
Okay.
Picketing is defined by law. Yes, my lord.
The Trade Union Act is cited in your submission.
Yes, in fact, my lord, we reproduced the provision of section 43, subsection 1 and 2 in our paragraph 7. We reproduced it clearly, and we made bold, it shall be lawful. It begins with that, subsection 1. It shall be lawful.
Subsection 1 of
section 43, subsection 1 and 2. We reproduce it verbatim in our submission in paragraph 7, where it says, it shall be lawful. And we also cited in the same paragraph the case of Chevron against Lupeng, where your learned brother, Kanyip J, restated the law on that you can't restrain a legal right. It's not possible. You can't restrain the right to picket. I reproduced the part of the judgment where your learned brother restated the law on that again.
That's in paragraph what?
Yeah, in paragraph 7, same paragraph 7.
Okay.
We restated it. Yes, so it's the right to picket is a legal right protected by law. Picketing is defined by law. It's a legal right provided for and protected. So the claimant cannot ask the courts to restrain a legal right. They don't have a legal right to restrain another legal right. It's not possible. They don't. And I urge my lord to so hold.
Okay.
That is the first condition. And secondly, my lord, all other conditions necessary for the grant of interlocutory injunction, they did not satisfy it. They did not. There is no legal right. There is no legal issue to be tried. Legal issue depends on legal rights. No legal right means no legal issue to be tried.
Yes.
No legal issue to be tried. The balance of convenience, of course, it's on our side, because we are the ones who our workers, ex-workers, are the ones suffering and dying since 1915. The ex-workers sued us, got judgment against us. Their leader has died in the course of this struggle without its benefits. Irreparable damage, we are the ones suffering irreparable damage, not the claimants. As we exposed in our written submission. And I urge my lord, to so hold, basically. And just as my lord also made mention, that the issues to be determined in this interlocutory application is so intrinsically connected to the substantive suit. The same facts, intrinsically connected. The release may be different, but the facts are the same. The facts are the same. And in that circumstance, my lord, I would urge that the application be refused and an order of an accelerated hearing on the substantive suit to be on the safe side. Because honestly, we don't see how you can really you can address this issue clearly without dealing with the facts of the substantive suit. Since
that's
the facts,
why wouldn't we find a way of determining the substantive matter in an accelerated manner.
I think that will be better, my lord. It will be better that way. It will be better. It will be better. Let's just go straight. And just as my lord observed, this matter can be decided based on it's purely documentary.
Yes,
it's really documentary. It's documentary. All the facts are based on documents and letters, which are already before the court. So we can just go dive straight into the substantive suit, file a written submission, and my lord delivers judgment accordingly. So that's because the circumstance of the case also needs accelerated because workers are dying. That's a painful part. Over 45 have died. Out of 245 have died, which is a tragedy. It's a tragedy. Fortunately,
but
yes.
If you can say, just to take one date.
Yes, my lord.
All the, parties to call. You have one witnesses, I think. One
yes,
witness.
My lord, that would be good for.
Huh?
Yes, my lord. Just one witness. The matter.
Yeah, so the witness will adopt their witness on oath. We, admit the documents, mark them as admitted without any objection. Then, so we going for adoption of final written addresses and judgment.
That will be better, my lord. It will be better, my lord.
My lord, that will be accelerated hearing will be very, very good, my lord.
So
the only thing we are saying is that the defendants should be put on check, at least for now, pending when my lord still determines
I can talk to my learned friends. I'm sure they will not do anything to prejudice the court's relationship, so long as this matter is being had acceleratedly. What we just want is for the matter to end and the workers get their salary, their terminal benefits, and let Union Homes have peace on its own. Because we're not safe. We don't feel safe at all. We don't feel safe. Because workers are out there. Yes, my lord.
They are very safe. Because
again, it's okay. Maybe I'll just deliver my ruling first. Then we give the matter as letter hearing. So that we'll just
My lord, I think that will be fine.
Since I've already taken the arguments of the council, but because that was what I thought yesterday, that why wouldn't you just adjourn this matter for give it as a letter hearing, take all the witnesses and adjourn for judgment instead of taking.
My lord, you have the inherent power to looking at the circumstance to rather than even ruling order accelerated hearing. It's within your powers, my lord. It's not an alternative to injunction to order an accelerated hearing in the circumstance. My lord, you have the power to do it even now.
My lord, I agree with that submission.
But then if that's the case, then how are you going to check the witnesses? Because from what I'm just thinking of the dates, when we're going to fix the matter for hearing, because for me, we can conclude this matter in a day. For me, we can conclude in a day. And I mean the trial, because there may not even be, you may not even need to, you can dispense with the cross-examination of the witnesses. Is that not?
We can, my lord. It's largely documentary, so no much story or evidence. It's documentary.
Yes, there's no much story. But there's some. It's just the date that our diary, because diary is with the registrar, and for this year we may not get a date in this year for and this and our order 3 rule that says, parties can with their agreement dispense with the issue of calling oral evidence and ask the court to try the matter or record. it has to be with the consent of the parties. That's number one. I think but as like if we, instead of rolling on this issue, maybe we adjourn the matter to. Well, can you people be able to, to gather your witnesses in a day?
Yes, my lord, we can.
Very well, my lord. They are based in Lagos.
Yes, and we can bring the witness. The witness is the legal officer of first defendant, so is someone that knows the importance of.
Okay, Mr. New Era. Mr. New Era. No, you are muted. You are muted.
Hello, okay. My lord,
Yes.
sir. Unfortunately, our witness is not in these proceedings, so as to get his firm words as to because the problem is,
yes,
we don't want to take a date now. I will not disappoint as per giving stories and all of that. So we want to be sure that
because they are submitting the facts contained in the affidavit in support of the motion are the same facts contained in the statement of fact.
yes.
Yeah. Yes. 100%. Same. Yeah, my lord, the same facts.
100%.
100%.
Well, it's even possible for one set of facts to give rise to different reliefs. It's possible.
Yeah.
That's what we have in this case now, my lord. So it's not entirely a mistake to have one set of facts giving rise to. Another worry which I entertain is that the Lord has taken applications.
Yeah, Mr. New Era, what are you saying? Mr. New Era, what are you saying? Mr. New Era, what are you saying?
I said I'm only entertaining a little bit of concern. I'm only entertaining a little bit of concern as per the fact that the Lord has taken the applications and have taken arguments on it. It's not ordinarily that the court must dispense one or the other application of the why I understand the need for us to have an accelerated hearing. Looking at the circumstance, I don't know if my lord will have crossed the Rubicon as per the application that is before the court. I'm thinking that since we have already taken it, it will be neater to have the Lord just have a ruling. And if we have rightly distinguished in our reply of point of law, the issues before the court in this application is different from the ones in the substantive case. Now, it's a different thing when you're asking the court to restrain pending the substantive, the hearing of substantive suit, and when you're asking the court to, restrain perpetually.
Okay, it's okay.
My lord, sir. My lord, sir.
Yes.
My lord, the purpose of this application is for an interlocutory injunction. And my lord has a right to order parties to maintain status quo and deal with the substantive matter. We have the right. I can talk to my learned friend. I'm sure he won't oppose that we undertake not to picket.
No,
and that solves the problem of what is afraid of.
Mr. Kenny. Mr. Kenny, this is saying that I should roll on the application. Let me just it's okay. We won't roll, then we'll adjourn for hearing. So that's all for you're done with your argument, Mr. Kenny.
That's so basically that's all. I'm done.
That's all. I'm done.
Recording in progress.
So anyway, since it's but I not to so prejudice this substantive matter should be brief, not to not to prejudice the not to prejudice the substantive matter. So I think I'm going to adjourn. And the date for the ruling will be communicated. It can either be virtual or physical. So that on that date, can we adjourn for? Anyway, let's just. I was just thinking that whether we can adjourn for ruling and here.
No, I think we can.
We can, my lord. We can. Since it be a short ruling and we'll just go into the substantive.
So that I won't tamper with the.
Please come and help me start.
So I'm going to ask the registrar to communicate the date to you for the ruling. So but I was just saying that this is a matter that can be purely dealt with, on documents, on a documents file, on documentary is in file. So case is reserved for ruling to a date to be communicated to council.
As court places.
Yes, so we will. But it should be Mr. New Era.
Hello, sir.
Just try to discuss this issue with witness. Because once it's done for here, we are going to hear, everyone. It appears to be a case that the military even need to cross-examine the witness. It's purely on documentary. Even if somebody is asking a witness some question, it will be one or two questions. Just one or two, maybe to confirm some, facts contained in the documents and all. So please, get ready that when we are joining the matter, if the registrar is going to call you, and if the registrar tells you that it will be for hearing, please gather all your witnesses so that I will just take this matter once and for all.
As the
Once
call,
and-
please.
and from the way I'm looking at it, it appears to be a simple issue. From my understanding of the matter. So that's all for today, gentlemen. I wish you a very good afternoon.
Thank you, my lord.
Thank you, my lord.
We wish you a splendid weekend.
Hello?
Hello, we'll wish you a very blissful weekend.
Thank you. Same to you. Bye-bye.
All right.
Go.